See, this is why I started a channel, for some juicy shit like this, man. This is a really good conversation between you guys. Failing to follow the terms of a contract is different than a contract that was illegal to begin with. An illegal contract from the beginning is illegal from the beginning, and such is void by operation of law. Any order declaring so is simply official recognition, but does not change the fact that it is still void by operation of law to begin with. Example, a contract to murder someone would be illegal from the beginning, and no order declaring such charges, in fact, is illegal by operation of law to begin with, and an order declaring so is simply an administrative formality. Very, very good. Yes. Now, I would also like to say that, so if you just look at, well, hold on, let me read what this guy put. It's a large stretch to state that there would be any kind of physical contract to perform an illegal activity, but I digress. I agree if the terms inside the contract are found to be not legal or binding in nature, that contract is automatically terminated, but it would never have a legal contract. This is still a bad analogy to the case, as there having been a criminal trial plea agreement, those just don't magically go away on their own. It would have to take a court order to vacate those findings, so still not an operation of law. See, okay, you're thinking too much there, which Jeremy, you're thinking too broadly, and you're also thinking that a contract is separate from everything else. Like, okay, a contract, a statute, right? Just a statute on its own is a contract. Just the words of a statute. Okay, so I know this is going to sound silly, but think of law not as in legal terms like a court or written statutes. Think of law as an actual law, gravity, something that only operates by operation of law. You know what I'm saying? Think about a contract like that. Gravity is the ultimate operation of law contract. If you don't put your foot down, gravity is going to, by operation of law, drop you to your fucking knees. You know what I mean? Like, and so that's what it means. But it doesn't necessarily mean termination. I don't know. I know Merv repeated that 100 times. And yes, it makes sense that if something is meant to expire, or that if something happens, then yes, you know what I'm saying? Like, that makes sense. I get it. But you're thinking about it as a written agreement. Like, you're thinking about an agreement, not a contract. Some other commenter, I don't know if it's a he or she. I'm going to call it a she. I think it's a she. But she actually put the exact words that I was going to say right here. Just like gravity, all contracts have a fair dealings. Look, just the very first part, what she said, all contracts have good faith and fair dealings implied in them. And that's true. For example, a statute. Like, you're assuming that contract between the lawmakers and you to abide by it, right, is going to have a good faith application whenever it's applied to something. Okay, well, to be honest, I find it hard not to be an operation of law by the nature of its legal impossibility. As pointed out, the charges were based on the validity of the injunction in the first place, and that injunction is declared to be whatever, then conviction based on it would be void too. How can a conviction for robbery stand where it's determined that no robbery took place? The same would apply with harassment. It's a moral and a legal conundrum. A hearing to get a declaration of void judgment note, voidable and void are not the same. It is not an appeal. There would be no need for an appeal. It's simply a hearing for a declaration. The declaration then is followed by writ to vacate. That's the word I was looking for, the conviction. It should work that way, but time will tell, and the courts so far have demonstrated that they will pull all kinds of shenanigans to stick it to lanes. Yeah, no, for sure. For sure. Okay, here we go. This is the part that I love this shit. The issue at hand is harassment doesn't require a civil injunction to be in place for it to happen. Okay, see, now what are we talking about? Are you talking about this case? Because in this case, yes, it does. It absolutely does. 100%. I think that's where if you're just saying in general, then yeah, it doesn't. You're right. But in this case, in the two charges that he signed his name to, absolutely it does. Just real quick before I show that, here's another one that says the Court of Appeal. Wait, no, I'm sorry. Blah 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 blah. To include information outside. If Myers files a brief to appeal the civil conviction and wins, what will the appeals court reference do anything with the criminal conviction? First of all, I just want to explain there's no such thing as a civil conviction. A civil conviction isn't one of guilt or innocence, right? A conviction insinuates guilt or innocence, and a civil conviction, I guess you could say, isn't one of guilt or innocence. It's one of liability. You know what I mean? Either one person's liable or the other person's liable for whatever event happened. It's not to justify if somebody's guilty of an event or not, or if they did it or not. There's no such thing as a civil conviction. That's ridiculous. But either way, to answer both of these, the charges on the criminal document that he was brought into court with, that was shown to the grand jury, are the exact same dates and the exact same behaviors that were on the civil injunction that got her the civil injunction. They are directly connected, directly related, directly intertwined. All right, let's write these dates down and see. And then right there on the bottom, you can see 10/9, right? October 9th. Okay, so here we go. Here are the dates. Now, let's look at the petition that she filed to get the injunction, right? This is technically the injunction, right? The dates and things that she used and the descriptions of them. Look at this. 9/12 exactly, 9/23 exactly, 10/2 exactly, 10/8 exactly, 10/9 exact. Literally, all these dates on the criminal charges are the exact same dates on the civil injunction that, let's say, it got dismissed, right? How could they possibly use that as evidence of, actual events, actual statutes, actual laws being broken, criminal activity? How could they use that if it was just dismissed, if it was just vacated as far as a civil injunction, right? Because even when they get the civil injunction, when the judge grants a civil injunction, especially one that's ex parte like it was, he's not finding any probable cause. He's finding reasonable cause to believe that there is evidence of harassment. It's not even probable cause or even reasonable suspicion or whatever. It's reasonable cause to believe that there's evidence, right? So it's not a finding of, but again, that's how they're using it though. That's how Rachel and them, as soon as a judge grants an injunction, they assume that everything that's on that petition is proof of whatever they're trying to prove, but it's not. Even if it's fact, it's still not proof of whatever the hell it is. It is just evidence, right? Again, some of you are still going to say, how does this relate to the criminal side of it? Okay, let me put it this way. Oh, in fact, don't listen to me. Let somebody else tell you. Okay, now look closely. If the charges aren't enough to tie it together for you guys, look right here where it says, in addition to the factual basis and the mens rea provided by the defendant, the grand jury or preliminary hearing transcript is hereby incorporated into the basis of the required agreement or whatever. Right? I'm assuming this audio is what she's talking about because it's the only thing that's close to a hearing. I mean, they kept calling it no bond hearing, eligibility hearing. They had 9 names for it, but this is the only hearing where there was actually one witness and some evidence. So I'm sure that's what this is. If that's not even enough, here's the preliminary hearing or whatever. So where the cop testifies, all right? So we got to believe the cop, right? I mean, everybody believes the cop, right? His testimony's like gold because they never lie. Okay, I'll try to do this real fast so you guys don't forget, by the time I get to my point. So this is the cop in the criminal case testimony.
And how are Lane Myers and Shannon Walker connected?
So they became connected through Shannon's husband, who is a prosecutor over at Tucson City Court.
Civil injunction against harassment petition. Lane Myers is a defendant in Tucson City Court that my spouse, Matt Walker, is prosecuting. That was the very first entry in the petition saying that why Lane Myers is targeting Shannon Walker was that my husband is prosecuting him, is basically what she said. So is the connection there? Is this connecting with any of you guys? I mean, are you making the connection, right? Okay. So even though the cop just told us, and we agree, and Shannon Walker agrees that the only reason Lane Myers was getting a hold of or trying to call the U of A is because and through the court case with Matt Walker as the prosecuting attorney prosecuting his case. Even though they all agreed that and said that, the judge still found that that is evidence of harassment in and of itself, and that it had no purpose, even though they both stated a purpose and all agree on it. You see how ridiculous this is? And that they're connected?
The relationship started, or at least my case started, due to Mr. Myers contacting Miss Walker through the court case through Tucson City Court.
Is that enough for you guys? I mean, it literally says on the thing that he signed that they're called the coercion agreement. It says that this and the grand jury transcripts are what they used, and plus Lane Myers' words about the facts or whatever, which we heard that one, right? And that wasn't even accepted by the judge in the first place. But that mixed with these two things, like this right here and that grand jury transcript document, are what gives them the factual basis, right? So if this is part of the factual basis, then there is a cop's testimony linking the two together to the civil injunction against harassment. Again, going off of the exact same dates that were on the civil injunction against harassment. And he goes even a step further, this cop does, and just told us that the only reason that Lane Myers contacted her was because of her husband and because of the Tucson City courts, and not just because of them. He said through the Tucson City courts, right? Through the courts. Think about that. And I have a question for everybody else that doesn't agree with the civil and criminal being connected and blah, 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 right? Why is it so possible or impossible for the criminal and the civil thing to be connected when the beginning of the criminal case on their half is literally everything that's in the civil complaint, right? The whole case is based on a civil complaint. How is it that whenever it comes time for an appeal or for somebody to look at the connection between them, there's no connection? But whenever the court case is going on and they're having a preliminary hearing, it's all about being connected to that civil case, dude. How can the prosecution use that and then deny it as a defense when the defense wants to use that connection? It's ridiculous. You can use a civil injunction as proof of criminal activity and actually get a conviction out of it. But then whenever that conviction is questioned about there being a connection between the criminal activity and the civil complaint, then it's just they're untouchable, right? One can't be used for the other. It's fucking stupid, dude. I mean, it's simple math, dude, and by this I mean like legal math. If the conviction is good, then the connection isn't there. But if the connection is there, then the conviction is bad. You know what I'm saying? Does that make sense?
That started with phone calls to her office at the U of A, and then him.
Wait, what did he say? One more time. What did you say there, Copper?
Her office at the U of A, and then him.
Boom! This cop is the best freaking witness for Lane Myers ever. I mean, I know it sounds like he's being a witness for the state, but really he's advocating for Lane Myers right now because guess what he just did? He just proved, because he's a cop, right? Everybody believes what cops say. We have to take every word that he says as truth. You know what I'm saying? He's under oath. He's a cop, right? He just said that Lane Myers never had any contact or directed any contact toward Shannon Walker at all, and everybody else who called too. He just said that nobody directed contact at her. He just said that. Oh, you didn't hear it? Listen to it again. He says that they called, the phone call started and came into the office at the U of A, right? Nobody contacted her or did anything toward her. It was toward the U of A, right? The U of A, the same people that posted the phone number that they're calling, the University of Arizona. The calls were made to a building, not to a fucking person, right? For example, if she were to get fired, somebody else would be sitting in that office chair with the same phone number. It's not a personal number. It's a call made to a building. And the fact that she never answered the phone means that they weren't directed at her. If she would have answered the phone, maybe she'd have a leg to stand on, and maybe that might make some sense, but it doesn't. And a cop just testified, and we have to believe the cop that the phone calls were made to a building, not to a person. So boom, injunction vacated.
Going down to the University of Arizona to try to speak with her in person, which then led to him creating YouTube videos speaking about Miss Walker and her husband and the conduct that he didn't agree with.
Remember this cop's words. He said, speaking about things he didn't agree with. Speaking. Still right there. I mean, he just told us that it was all the stuff that Mr. Myers said that was negative about either of them is protected speech. It's political speech. He was talking about somebody who is a government official, right? I mean, Matt Walker and Shannon Walker. It's not his fault, Mr. Myers' fault, that Shannon attaches herself to fucking Matt Walker. You know what I mean? But I mean, the cop said it was both of them, right? And if it's both of them, then you know what I'm saying? You can't make a statement like that and connect a private person that's married to a government official and then only say that the speech toward both of them was toward one of them. That's ridiculous, dude. This cop literally just completely invalidated the petition. He invalidated the petition with answering 3 questions. He invalidated that entire petition.
Object on hearsay. I realize the purpose of this hearing, but since everybody's watching on YouTube, I'm just...
And it was objected to. The one thing Parvin did, right? I mean, the one objection that he made, that's what it was too. I mean, give me a break, dude. This screams. If you guys can't get a little whiff of corruption or just a little hint of dishonesty in this, then you're fucking retarded.
Objecting anyways, the court can explain why that'd be overruled.
So I will overrule. Hearsay is admissible at these proceedings. Ms. Stiles, I am going to ask you to lay some foundation as to witnesses who are going to be available at further proceedings in this trial before you go forward with that, however.
Yes. So, Detective, for this information that you gathered, how did you gather this information?
There were reports from the victim to the Tucson Police Department asking us to investigate harassment charges.
First of all, you don't investigate charges. You do an investigation and then you charge, right? If what he's talking about is to investigate to see if there was actual harassment, if that was the case and if that's what he's actually talking about, guess what? There was no charges at the time. They didn't come until 4 months later. So what he's saying is at the time, there was nothing telling them that there was enough probable cause for him to be arrested for harassment. So again, how can the civil injunction that they convinced the judge of, how can the judge find that and a police officer who's actually taking these reports and is in the streets and whatever doesn't find that? How is that possible? Because you have a prosecutor husband. The only difference between whenever the cops were presented the evidence and when the judges presented the evidence is the fact that Matt Walker is sitting right behind Shannon Walker whenever the judge was presented the evidence. As it was happening, when the cops were presented that evidence, as it was that day or whatever they saw, according to their training and blah, 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 they didn't see enough to arrest him. You know what I mean? And cops are fucking vicious, dude. They'll arrest anybody for anything. There wasn't even an iota of evidence of harassment because, you know what I'm saying? Those cops would have been all over that. They hate Lane just as much as everybody else does. You know what I mean? Like, give me a break, dude. The only difference is Matt Walker sitting back there stroking her. You know what I mean?
And later on, violations of an injunction against harassment that she had filed against Mr. Myers.
And have you spoken with the victim?
I'm not sure if Shannon Walker got her name legally changed to first name the, last name victim. I don't know if that's legally a name change that she got or something, but this is probably the 100th time Rachel has referred to her as the victim. Now, here's the thing. As deceitful as that is, and as minimus as everybody makes it, is fucking stupid. You guys are all stupid for allowing her to continue to call Shannon the victim when she's not the victim, right? Because the victim would indicate that there was a conviction against Mr. Myers previously against her, but there's not, right? And if there was, check this out. You just heard the cops say that they were investigating harassment charges or whatever, right? If there was a previous conviction and she was a victim of his, they would have instant probable cause to arrest him, regardless of anything that he actually did. And any connection that they could make between him and her is arrestable, right? They literally would have had probable cause to arrest him on any one of those dates that they have named there, but they didn't because he is not a convicted offender against her. You can take each one of these events on the petition as evidence of his guilt, or you can take it for what it is and see that it's evidence of a non-arrest, right? Because if what she's saying is true and she was a victim or is a victim or has had any domestic anything with him in the past that led to a conviction, the cops, those would not be dates of events. Those would be arrest dates, right? And the fact that they're not is, again, proof of Lane Myers' innocence in this case. I mean, for that matter,
I have.
And are you aware of whether she will be available to testify at trial?
She will be.
He didn't ask if she was going to testify. She asked if she'd be available. But anyways, that's not the point. The point is now Shannon Walker is a plaintiff, victim, and a witness, right? These are all things that happen at a trial, right? These things never happen. She was never victimized because there wasn't a trial. She's not going to be a witness and hasn't been a witness because there's been no trial, right? It's just, this is all just stuff that the cop is saying. You know what I'm saying? Dude. And she's hardly a plaintiff. She shouldn't even be a plaintiff, right? I mean, at least that one she was in court and had to say words for, or at least that's what we think. I don't know. We don't even know if that's true. But either way, she was sitting at one point in front of something that resembled a judge, right? But the problem is Lane Myers wasn't there, right? So two of the things that she is require a court case to happen, being a victim and being a witness, which she's never had. And then the one thing that she is considered to be a plaintiff was only granted to her because Lane Myers wasn't there.
Now, the information that you were gathering, was that just from Ms. Walker, or were you gathering it from other sources?
Okay, my bad. Plaintiff, witness, victim, primary evidence contributor / investigator, I guess. So those are all the things she is: plaintiff, victim, witness, evidence gatherer / investigator. Oh, and then plus her actual job of being whatever she is at the U of A. So those are all the things that she is in this case. Oh, and lawyer. I forgot she was her own lawyer at the contestation hearing where she got 14 pieces of evidence heard and admitted into evidence. They were admitted into evidence before she even got there, and then they were published or played out loud, and while Mr. Myers got none and none.
So I was gathering it from Miss Walker, but I was also gathering it from Mr. Myers' YouTube channel that he is active on. I wouldn't say on a daily basis, but he's very active on it. So obtaining videos through his YouTube page and through other YouTube pages that associate with his.
Yeah, once again, you're confusing Facebook with YouTube. Facebook has pages, YouTube has channels, and channels don't, or pages don't associate with each other. People do, okay, douchebag?
Were you also in contact with Matthew Walker?
I was, yes.
Okay. Was he providing information to you about what was going on?
He did also provide information in relation to Shannon being contacted due to his work.
Holy shit. Shannon being contacted due to his work. There we go. Mystery solved. None of those communications or attempted communications were about her. It was all about his bad, very bad conduct as a prosecutor.
With a case that would involve Mr. Myers over at Tucson City Court.
And
oh, badass. So it's specifically about the case that involved Mr. Myers at Tucson City Court. Perfect. Thank you. Thank you for clarifying. That's all we need, buddy. You're dismissed.
in speaking with him, are you aware of whether he will be available to testify at trial?
He will be available as well.
So now you referenced that Mr. Myers has a YouTube channel. How do you know that that's Mr. Myers' YouTube channel?
Because you can clearly see him on the YouTube channel. He appears physically. He often says his name, so it's clearly him.
So in relation to what Mr. Myers was doing with Miss Walker, when did that approximately start?
What Mr. Myers was doing with Miss Walker? What were they doing with each other? What you hear how you see how they have nothing to actually connect them, right? That's what's so bad about this, dude. There's nothing actually connecting them. Yes, Matt Walker. Yes, the Tucson City Court case, but nothing else.
It approximately started September, October of 2024.
And then how often has this been going on?
So it's still currently going to this date. The harassment that she felt was up to the point where she obtained the injunction against harassment in October.
Oh my God, dip me in shit and roll me in breadcrumbs. I'll be a monkey's uncle. Listen to that. He actually said injunction against harassment and then said the date that it was, but not the date that it was confirmed or validated or officially whatever upheld, right? He said the date that it was lied about in October, because it wasn't until November 15th that it was actually upheld, right? So And it was appealed, so we don't even know if it was lawfully upheld yet. We still don't know that. How could they base any of this off that injunction if we don't even know if it's been lawfully upheld yet? The appeal is, there's still an appeal on it to this day, right now, as I speak. So what the fuck, dude? How can you have it both ways? How can you say that there's zero connection between the criminal case and the civil injunction when literally the civil injunction is still not even a final thing? It has still not lawfully been upheld because there's an appeal on it. You know what I mean? How could any of these decisions been made, and how could they accept a conviction or whatever confession? How can they accept that as a factual basis if the factual basis isn't even actual fact yet? You know what I mean? This is fucking stupid. You guys are all stupid. All you guys are fucking retarded. On top of that, in the same breath this cop just used to tell us that there was an injunction against harassment that they're basing this all off of, this criminal stuff all off of, in that same breath, he testifies to another person's feelings and how they felt, right? And I'm sure that this is what they're using as part of their factual basis, is the cop's testimony on Shannon's feelings, right? This is clown show, dude. This is a clown show.
Of 2024. That injunction was then modified in November of 2024, and it is still active today. And she still is receiving things that are harassing in nature.
She's receiving things that are harassing in nature. Things. She's receiving things. He didn't say phone calls. He didn't say. He said things. Receiving things. That is such bullshit. And harassing in nature, that doesn't make any sense, dude. Harassment is it's so personal that it has to be directed at you, right? There's nothing that is naturally harassing, dude. There's no such thing. It makes no sense, dude. This shit bothers the hell out of me, dude. That's like harassing in nature. It does not make sense, dude.
To this date.
Okay. So prior to getting those injunctions,
she has one injunction, right? She did multiple petitions, if that's what Rachel's slip of the tongue was, right? Illegally, unlawfully, did multiple petitions, but there's only one injunction.
can you just give a brief description of what type of behavior was happening that led to the injunction?
Now all of a sudden there's one injunction. What the fuck?
So she was receiving phone calls from third parties. Mr. Meyer went on his page and he was encouraging his followers to reach out and contact Miss Walker in relation to the conduct of her husband.
Yeah, whatever. He's trying to, you can tell he's pulling that from memory. He's reciting words that he'd memorized. Like that whole thing, you could just tell he's doing that. Anyways, I don't even give a fuck, man. I'm over it. This video, I'm working on another video about something else. This is fucking stupid. Y'all are all fucking stupid. I'm not talking about y'all, like the people, I'm talking about like the prosecution, you know what I mean? Like the government people are stupid, not y'all. Y'all are badass. Yeah, and like this guy says, he says the issue at hand is the harassment doesn't require a civil injunction. That's when I started going off about this. But he does go on to say I'm not completely solid on all the charges of this one. But he said, I do know that you can be charged and found guilty of harassment without a civil injunction in place. Exactly, you can. That's exactly right. And you need things like a personal relationship or previous history of domestic violence or all the stuff that Lane Myers and Shannon Walker don't have, right? So the state's only option to fabricate this history or fabricate these things that you need to have harassment and then eventually get a conviction without a civil injunction is to get a civil injunction, right? And then that's how they fabricated all these, things that are supposed to happen in connections that don't exist or whatever, But the problem is that they had to use Matt Walker to do it, and the problem is that Matt Walker and Shannon Walker can't figure out how to not show a conflict of interest to the public, right? Anyhow, moving on. So I realized they were talking about his behavior, before the injunction was in place or whatever. But since the injunction was in place, he has been arrested after he had the legal civil injunction against him, right? But here's the thing. Look where it says no contact. Defendant shall have no contact with plaintiff except through attorney's legal process and court hearings and as checked, right? So the legal process and through the courts, the cop literally testified that he had contact with Shannon Walker through Tucson City courts, right? And her husband, literally testifying that he had what if whatever contact was considered contact to her was through the city courts, right? Which means he did not violate his injunction against harassment, if you consider it valid, which I don't. And here's another thing that's been bothering the absolute shit out of me, right? How can they use like these URLs as far as evidence goes? Because they're using these URLs, and I've seen the one where it has like everything that they considered was one of all 14 of the whatever charges that all independently have their probable cause, which is bullshit. I've seen all those, right? And they're using these URLs as far as evidence to go look at it, right? This is evidence. This is a police report with evidence of his crimes on here, right? Well, how can they accept his confession, and part of the agreement of him confessing and getting on this probation is to destroy evidence? Like, the case isn't over, you know what I mean? Like, it's not, you can't destroy evidence, dude. It's evidence tampering or whatever. All the evidence of what they used to convict him is now gone off of his webpage, right? And I don't know who the custodian of the evidence is, or the custodian of the YouTube videos, and that came up even in the case. Doug Metcalf asked about it, and she said to be determined or not determined yet or whatever. And I think that's why, is because they planned on deleting the evidence after they came up with, or after they, they coerced him into a signature or whatever. And I think that's proof. The fact that there is no custodian of record for the actual YouTube evidence, I think that's proof of them maliciously knowing that this is what they were going to do, and that they were eventually going to take they knew that they were going to get him out. They were going to put these conditions on him, and that he was going to have to take them down, right? So if they would have put custodian of record, somebody that was actually a tangible custodian of record that would actually have to take custodial control of these pieces of evidence and keep track of them, and you know what I mean? They just didn't do that because they knew they were going to delete them, which is what I think. And I'm not accusing them. I'm just saying that's my opinion. Anyways, here's some final thoughts to stay with you guys till the next one. Just kidding. Bonus. All right, here's some bonus content for you. Bonus content. It sounds something like, anyway. So, if Mr. Myers had an injunction against harassment and he was violating it right in front of the cops, if everything was on the up and up and everything was good, legal, all the I's were dotted and T's were crossed and whatever, then you would think that if the cops saw Mr. Myers violating his injunction against harassment in a courthouse right in front of them after it's been validated and agreed that it's been valid, and not just valid, but confirmed, upheld, days after it was upheld, and Mr. Myers even shows it to the cops and says, this is a valid injunction against harassment, you can arrest me right now, arrest me. You would assume if everything was on the up and up that he would be arrested, right? Well, that situation actually happens, and the cops said, well, you should go talk to the judge, blah, 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 blah. This is proof of the conspiracy, that's all.
Guns within 24 hours. Well, I'm a convicted felon and don't own any guns, so what the fuck is, and then it says that I'm ordered to remove any videos. I'm not taking them down. So you want me to take me to jail right now, or what? You want to go from here to jail, or what? I think that can be an issue with you, but the judge comes down. Because I'm not taking them down. You get what I'm saying? Yeah. And because I just went to a hearing on Thursday with another one of these, and the judge said I can't make him take his videos down.
Yeah, you can work that out with the judge to say.
But I'm saying you can arrest me for him.
Or you can use the opportunity to try and file
an
audience with the judge about that.
Yeah, no, I'm gonna go over there and schedule the thing. But you get what I'm saying? The slippery slope around now.
Funny, it seems like so much work just to get somebody on probation. You know what I mean? They should have just left him in jail. Why probation is the thing? Why?
But I am aware that probation is allowed to curtail your First Amendment rights, and that may have impact on other people.
Wouldn't it only be like one way though? Like Lane wouldn't be able to contact them, but they could contact him, but he can't do anything with the contact, so it'll only be technically affecting Lane in that way.
I don't know. There was no
the victims could always go back to court and get restraining orders against other peoples in their jurisdiction.
Yeah.
Okay.
Whoa, yeah, let's totally pause when somebody comes up with a good suggestion that actually might make legal sense and also moral and, be fit the situation properly, like people getting their own restraining orders in their own jurisdictions, right?
Let's pause for a
but
second because we have a question. The question was there any jail time?
Only
So
time
Judy,
served. There's
he got his
only,
time served.
and now being on probation, there were 2 felonies
Okay,
that he pled guilty to. Each felony, the judge assigned him 3 years probation, but to be run concurrently at the same time. Now, I know probation. They have ways.
And this is the whole crux of everything because we all know, Lane, all of us that watch in whatever, he bends over backwards to follow the law. He respects the law. I don't, but he does. And he does everything he can to follow the law, as long as he knows what it is, as long as it's not being fucking kept from him or, you know what I mean, or vaguely fucking whatever described. He is a man of the law, right? And the reason that they did all this work to get him on probation is for this exact reason right here.
I mean, you can violate on probation with something that is not against the law. Violate on probation with something that is not against the law. Violate on probation with something that is not against the law. Violate on probation with something that is not against the law. Is not against the law. Technically. Not against the law. Not against the law.